Rhanee Rego is likely to be well known to anyone following wrongful conviction cases in Australia in the last few years. As lawyer for Ms. Kathleen Folbigg, Rhanee was central to delivering justice in that case in 2023. Here, Rhanee reflects upon the whole process of working on Ms. Folbigg's case, and in particular focuses on aspects of that process that are in desperate need of reform.
A real pleasure to be here with you today. Unlike my other co-speakers, I'll be using a PowerPoint. I am still not out of the teaching mode, and I find sometimes visuals help. So the purpose of my talk today, as alluded to by Robin, is to share with you some of the experiences that I've had in working with Kathleen Folbigg in her attempt to navigate a really poorly designed and structured system in New South Wales. Ms. Folbigg also wanted me to pass on her thanks to all of you for being here today to discuss this issue that affects all of us, but in the past year, certainly her in a really significant way, well, really 24 years. She just said thank you for all of your concern and keep up the good work in bringing the issues to light. So I've actually changed it around a little bit from what I was going to do previously. I've gone a bit far now. Okay, so the overview of my talk is going to be firstly about Kathleen Folbigg's case. And because it is such a high-profile case, most of you will know a lot about this already. So I'm going to share with you some of the more interesting facts that you may or may not know about that we have found over the time working with Kathleen. Then I'm going to set out briefly what are the post-conviction review mechanisms available to people in New South Wales. Then lastly, I'm going to share some of the insights into the system, having worked with Kathleen in that system. So, as I said, most of you, if not all of you, will be aware of Kathleen Folbigg's case. She is a woman from the Hunter Valley of New South Wales who in 2003 was convicted of 1 count of manslaughter, 3 counts of murder, and 1 of inflicting grievous bodily harm on her second child. The Crown case was circumstantial entirely. According to them, she smothered her children each over different periods of time in a state of rage or stress, one after the other. They did provide an alternative motive, which is quite odd, that they said she was either hated her children or she wanted to render them unconscious to get some sleep. So, I'll leave you to ponder the incongruity with both of those things, particularly when after having smothered Caleb, she probably realised that murder is permanent, so you wouldn't do that a further 3 times if it was just to put them to sleep. There was no forensic pathology evidence from the 4 separate autopsies suggesting smothering. And in the absence of that evidence, it was perversely framed that an absence of smothering signs indicated she did smother them. A key element at the heart of the Crown's case was an already debunked theory called Meadows' Law. This is a famous dogma that is along the lines of 1 infant death is a tragedy, 2 is suspicious, and 3rd is murder until proven otherwise. In January 2003, some few months before Kathleen was taken to trial, this Meadows' Law and the proposition that underlies it had been refuted in the appeal of Sally Clark in the United Kingdom, who had been convicted, like Ms. Folbigg, based on this premise rather than forensic evidence. Ms. Clark's successful appeal and its cautionary tale was presented at Ms. Folbigg's trial by the defence, but sadly, Meadows' Law reasoning still infected Kathleen's trial in really important ways. A handful of diary entries written by Ms. Folbigg over 10 years were, according to the Crown Mark Tedeschi, the strongest evidence of her guilt. And the jury were encouraged to read those virtual confessions that she'd murdered her children. Ms. Folbigg wrote over 50,000 words. She was a prolific writer throughout her whole life. And I do know there was that many because I transcribed every single word. And my fingers nearly fell off. But only a handful of entries within those were emphasised by the Crown. And we will never know if the jury or indeed the 17 judges who sat in judgment of her ever read her full diaries. We know Mr. Bathurst did, but before that we don't know. Following conviction, Ms. Folbigg had 3 substantive appeals, 1 appealing her conviction and now 2 inquiries. You might be aware that Mr. Bathurst was the latest inquirer, and he found that there was reasonable doubt in relation to her convictions. And she was released through the exercise of the Royal Prerogative of Mercy, a pardon, on the 5th of June last year after having served 20 years in prison. Her convictions were quashed by the New South Wales Court of Criminal Appeal December last year, 14th. So now moving to some of the more interesting, well, the whole case is interesting if you ask me, but some things that you might not know. And all the while that I'm talking about these things, I just want you to bear in mind that this case was always a miscarriage of justice right from the beginning, right from the 1st of March 1999 when Laura, the fourth child, died. And you can see some of these interesting facts as being an accumulation of the miscarriage over time. So I'm taking you back to the year 2000. Professor Caroline Blackwell was a leading SIDS researcher from the University of Edinburgh on sabbatical at the University of Newcastle. Craig Folbigg, Kathleen's ex-husband, phoned Professor Blackwell in 2000 in response to a newspaper article that they'd put out about their leading research in SIDS and talking about their findings. And he'd called her to see if he could put Kathleen's DNA and his DNA into that study that she was doing so that he could obtain some evidence to push back at the police. So there is a misconception around about this case that Craig Folbigg was always against her, his wife. That is actually untrue. The timeline, if anyone's interested, I can point you to where we put it in our submissions, but he was very much supportive of his wife for a long time until he was arrested with hindering an investigation. So unfortunately, Professor Blackwell explained that she couldn't put the DNA in her studies because of university ethics, but that she could think about what she could do. Interestingly, about 2 days later, the detective who was looking into this matter dropped in to see Professor Blackwell. Wonder how he found out about that. It might be listening devices, but anyway. And he had mentioned to Professor Blackwell about this case, and she said, "Oh, that's really odd. I just only heard from the husband 2 days ago." And she said that while she hadn't seen the medical and autopsy information for the 4 children, her research suggested that there could be a physiological process that could explain the 4 deaths, and basically you shouldn't jump to suspicion. She said that she could do some testing, send it to her team in Edinburgh, and just as fast as she made that offer, Detective Ryan said, not interested, it's too expensive, without actually inquiring as to the cost. So the next interesting thing, I'm taking you to the year 2001. And so Detective Bernard Ryan had sent a brief of evidence to the DPP asking their view on it and whether the charges can be laid. And Gregory Coles, who's a very senior DPP, indicated, as you can see on the 2nd of February 2001, that having looked at that brief of evidence, that he recommended that the state coroner investigate the matter as an inquest. He was obviously not satisfied that there was sufficient evidence at that point to lay charges against Ms. Folbigg. And notably, the brief of evidence never got any stronger than at this point. They had all of the expert reports that had said murder. So clearly at this point, Gregory Coles was not persuaded that it was a criminal matter as distinct from having a look at it in the coroner's jurisdiction. So the then Deputy State Coroner Janet Stevenson met with police and decided very quickly that she should be charged with murder, and she did not exercise her powers under statute to have an inquest hearing. So I'll take you to the year that Miss Folbigg was taken to trial. So at Miss Folbigg's trial, Mark Tedeschi, the Crown prosecutor, emphasised the fact that 4 deaths in the one family from natural causes was a world's first event. The Crown asked the prosecution witnesses similar questions, but to this effect: have you in your experience or in the literature heard of a case of 3 or more infant deaths from natural causes or SIDS in the one family? Each of them answered no. As you can see on the screen here, I've listed the articles that were existent before 2003, which record 3 or more deaths in the one family from either natural causes, unidentified natural causes, but SIDS is a diagnosis of exclusion. So that was clearly incorrect evidence from the prosecution witnesses. And you can see even in, I think it's might be the second one, there was 5 deaths in one family. So the fourth listed article is of particular importance in relation to the next slide. So it's by S.M. Beale and H.K. Blundell. Susan Beale was a prosecution witness who gave evidence that she'd never heard of a case of 3 or more infant deaths in the one family. Yet, this is her article from 1998, in which she lists a case of 3 SIDS deaths in one family. Now, Mr. Tedeschi, in introducing her eminent qualifications, did take her to the fact that she'd published in the Archives of the Diseases in Childhood, which was a very eminent journal of child health at that time. Funnily enough, Professor Roy Meadow was the editor, and she somehow didn't remember that she had published that. Now, interestingly, that evidence around the instances of multiple infant deaths was so clearly significant to the trial that the first inquiry in 2019 was ordered on the basis that there was a doubt or question in relation to this evidence. Importantly, it was actually raised as a ground in a 2005 appeal, but clearly not the Crown nor Defence did their research to find those articles. Now, 20 years later, the case still keeps on giving. In the last inquiry, the Bathurst inquiry, I became aware in February. So we had our last hearings, the last hearings in February and the closing submissions in April. We were given Craig Folbigg's ERISP. We'd never seen that before. And why that's really important is because while Craig Folbigg's evidence in the case was not overly persuasive in what he was saying, it was symbolic that he was against his wife, and it was particularly important in relation to the morning Sarah died. And in that ERIS, there was a lot of important information about the fact that his evidence was unreliable, a matter Mr. Bathurst has indicated in his report. We've also still never seen some statements from Mr. Folbigg. They've never been disclosed to us. There was also 123 pages from Miss Folbigg's diaries that had never been included and tendered, and one diary completely was never tendered to trial. So I've skipped a bit. We were also, and this comes back to Bob's point about non-disclosure, and I think it's a theme running through a lot of miscarriages of justice, is non-disclosure, and the bench judicial officer's unwillingness to actually really chastise for non-disclosure. So we became aware on the last day of hearings the existence of 530 hours of listening device recordings that had never been disclosed. So we still don't have them. We have no idea what's on them at all. Safe to say there's probably nothing inculpatory. It's probably exculpatory, if anything. And we also were given 86 new medical records during this inquiry from the DPP, some of which were really important in relation to Sarah's death, which was no doubt, in my mind, what the prosecution regarded as their strongest count in relation to the deaths. So, as you can see, there's been a lot of errors along the way for Ms. Folbigg, and that's just not even the tip of the iceberg. Very happy to talk about them at length with anyone wanting to talk about them, but you might need a lot longer than half an hour. So now I'm going to turn to talking briefly about post-conviction review in New South Wales. So we've really got 2 chief pathways for people who have exhausted their right to appeal. And one is to the governor and the other is an application to the Supreme Court. A convicted person can also petition the governor for the exercise of the royal prerogative of mercy. However, this is distinct from the pathways of challenging the conviction because a pardon only removes this sentence imposed on an individual. It doesn't remove the conviction. So I'm going to note the Supreme Court review mechanism first because throughout the remainder of my talk, I'm going to focus on petitions to the governor. So under Section 78, you can apply to the Supreme Court. Now, they're acting administratively, not judicially. And upon that application being given, a judge can either grant an inquiry or they can send it to the Court of Criminal Appeal to be dealt with as an appeal. Now, interestingly, with this avenue, the judges, the judicial officers who consider it do publish their reasons on New South Wales case law. So that does give some indication of why they've rejected it. And overwhelmingly, the success rate is very low. Now, the next avenue is a petition to the governor. So, of course, the governor is an administrative actor. You can either petition for a review, which can then lead to either an inquiry. It can, like the former avenue, lead to an appeal to the Court of Criminal Appeal, or there's a third option available under this avenue. The Court of Criminal Appeal can be asked to give an opinion on any matter arising in the case. Now, that is exactly the same. Those three outcomes are exactly the same as if you were to petition for a pardon. So what that really says is irrespective of what you're asking for, ultimately the Attorney General, who gives advice to the governor, it's not the governor who makes the decision, can, in their whole discretion, do what they like with the matter. So it's a bit of an interesting pathway. So just to give you the idea of what they have to satisfy, if it appears that there is doubt or question as to the convicted person's guilt, as to any mitigating circumstances in the case, or as to any part of the evidence, that's when the governor or the Attorney General or a judge of the Supreme Court can direct the outcomes. So I hope I've written an article on this that goes into a lot more detail. So if anyone wanting to know a bit more about that, I'm certainly happy to supply that to you. It is just publicly available on the Wrongful Conviction Law Review. I wrote it in 2021. If I had more time, I'd go into a bit more of it. Yeah, we're pressed for time, I think. Now, like with everything in post-conviction review, it's usually reliant on the convicted person being able to present fresh or new evidence. And of course, fresh evidence is, in judicial terms, looked at in a better way, because fresh evidence is something that couldn't have been obtained at the time, as distinct from new evidence that could have been obtained with reasonable diligence at the time. So, before we move into some of the criticisms of this area, I just will describe the petitions Ms. Folbigg has had over time. Ms. Folbigg's first petition was presented to the governor on the 26th of May 2015. It sat with two attorneys general for over 3 years. An inquiry was ordered on the 22nd of August 2018, 9 days after the broadcast of an Australian Story program aired on Ms. Folbigg's case. The first inquiry was not ordered on the basis of fresh evidence, which is an interesting point, as I said earlier. It was ordered because of the incorrect evidence that I indicated to you on the earlier slide with the articles. As I have shown, yet those articles were there, and it really should have been a role of the Crown and the defence to have found those prior to trial. The second petition requested a pardon. It was presented to the governor on the 3rd of March 2021. 91 eminent scientists and doctors endorsed our petition, including 3 Nobel Prize winners, former chief scientists of Australia, and domestic and international experts. Shortly after we presented it, the President and 66 fellows of the Royal Society of New South Wales endorsed the call for the pardon. Later, a 4th Nobel Prize laureate, Professor Brian Schmidt, also supported the petition. Now, I must say, having a lot to do with scientists over my short career, they don't agree on anything. So the fact that they all came together in support of this, I think, is a testament to the miscarriage of justice Ms. Folbigg has suffered, and that they could see the probative value of the science in this matter. And our petition has always argued that Ms. Folbigg's case was a miscarriage of justice from the beginning. And in some way, the genetic evidence was just a new lens in which to shine the light on that issue. It always needs, I can't remember who mentioned the term circuit breaker. I think it was you, Bob. You always need a circuit breaker. You need something to reinterest the public, reinterest people who are going to put pressure on there, because, like I said, 17 judges sitting in judgment of Ms. Folbigg, and not one of them gave any relief to her. So it's not confident going down the same path would be so beneficial. So as I'll discuss now, my experience of post-conviction review is that it's a highly secretive process. It's highly discretionary, it's cumbersome, and it's complicated. In the tragic cases in which someone has been wrongfully convicted for a substantial time, the burden is entirely on them to prove their case. In Ms. Folbigg's matter, there was substantial pro bono legal assistance, huge media coverage, support from the scientific community and the public. We even had a PR team come on board pro bono. If I told you the depth of the support, you would be shocked to know that it took that long to get one woman out of jail. So in my criticisms, I'm going to restrain myself and not be defamatory and just cover 4 areas. But as I said, I'm really happy to talk to anyone further about these issues and others if you're interested. So the first of the areas of issue are accessibility. So in New South Wales, a convicted person has a significant structural barrier to accessing the review system. First, the system assumes that a person can come with fresh or new compelling evidence to challenge their conviction. For good reason, post-conviction review mainly focuses on those cases in which the applicant can demonstrate that. But what happens when, it's a miscarriage of justice, and how can they obtain expert opinion from the comfort of their jail cell? How are they going to structure a review? How are they going to obtain all the court documents that they need? So most individuals will not have pro bono legal assistance or pro bono expert opinion, and they'll be unable to access the necessary legal documentations with no powers of compulsion. So assume for a moment that a convicted person is able to obtain everything they need. How do they go about constructing the application if they don't have a lawyer to help? There's no detailed information from the government issued about how a petition to the governor or the application to the Supreme Court should be constructed, or what essential information they require to assess the matter. A lack of access at the first step is a structural hurdle that would mean so many people sitting in jail would just not even attempt to have their cases reviewed. So the next issue that I will talk about is resources, and it really does overlap with accessibility, but I think it's important to point it out as a distinct area. It requires a lot of resources to overturn a miscarriage of justice. If a convicted person is lucky enough to have a legal assistance, it would need to be on a pro bono basis, because most people can't afford lawyers. I mean, even people with a good income, it's difficult to afford us because we're extremely expensive. And if a case requires expert opinion, they'd probably need to have that pro bono too. So in Kathleen Folbigg's case, the vast majority of work done on her behalf since 2015 has been pro bono. I am really not saying this to obtain a pat on the back for me or anything, but just to demonstrate the level of commitment that it requires to help a person. Dr. Robert Kavanagh, counsel in the matter with me, has worked for Ms. Folbigg since 2014, so a decade now. He and I have worked thousands, and I'm telling you thousands of hours over 10 and 7 years respectively that we've been involved. And at times we've both had to put our practice completely on hold and work on this completely, which is difficult. For example, at the last inquiry alone, both of us worked in excess of 3,500 hours, of which only 250 were paid by legal aid. And that doesn't factor in the huge amount of work done by Dr. Greg Woods, senior counsel for Ms. Folbigg, most of which was done pro bono. As for expert opinion, the scientific community have been extremely generous to Ms. Folbigg. Professor Stephen Cordner, Australia's leading forensic pathologist, prepared a 120-page report reviewing the Folbigg children's autopsies in 2015. This was done for free. Dr. Robert Kavanagh and I obtained expert reports from 5 experts in psychiatry and psychology in 2021, the first time that's been done in her case, and that was all pro bono. The experts were told up front we had no money, and I was thinking, oh gosh, I hope that's not the end of it, but they were generous enough to help us out. Most of the genetic experts who'd been investigating the mutation in the 2 girls worked for free, including the courageous and amazing Professor Carola Vinuesa, who dedicated a significant portion of her time because she felt there was something wrong here. We've even had a media and PR firm in recent years. We've had politicians, we've had business leaders, you name it, behind the scenes trying to get Kathleen out. And what that really says is that, does it take all that support for people to get out of jail who have been wrongly convicted by the system? Another significant issue is timeframes. I think that we can all agree, of those who have acted in miscarriages of justice or have an interest in it, that timeframes is one of the biggest barriers to obtaining justice. So Part 7, which contains the avenues, Section 78 and 76, the Governor and the Supreme Court, contain no timeframes within which a decision maker is expected to provide a decision. In my experience, timeframes are certainly not forthcoming from the Attorney General when asked. The first petition for an inquiry took over 3 years for a decision to be provided and grant an inquiry, and no reasons were given for that time frame. For the second petition for a pardon, it took from March 2021 to May 2022 to receive a decision. We were never informed about what was actually being done to assess the petition or give any progress updates by the Attorney General. And I know you don't know me, but I'm a very persistent woman. And when I say that I asked a lot, I did, and the answers that were given were less than acceptable or tolerable to me. In another case, a colleague of mine made an application under Section 78 to the Supreme Court. Like in Ms Folbigg's case, the applicant was convicted of murder. And like the first petition for Ms Folbigg, it sat with a judicial officer for 3 years. And in that instance, it was denied. So timeframes really don't differ all that much if you look at the substantive nature from either avenue. My issue with timeframes, though, is not so much of the time it takes to review a matter, because I'm fully aware that matters are complex. They take time. We have other things we have to do. But the main issue is where there is no explanation given, well, what is an acceptable timeframe? And having regard to what is it, it's not as if the Attorney General or the judicial officer is having to make a determination as to whether there's reasonable doubt or not. All they have to be satisfied with to order an inquiry, send it to the Court of Criminal Appeal, or ask for an opinion of the CCA is whether there is doubt or question. And that is substantially lower than finding that there is a reasonable doubt. So it's also very important, in my view, and I think you'll all agree with me, to know the progress of a matter when you're acting for someone and to be provided reasons why the petition was granted or it was denied. As I mentioned, in the case of the Supreme Court mechanism, they do publish their reasons, but in petitions to the Governor, my experience with the now opposition leader, Mr Mark Speakman, is that he's very reticent to give any explanations about his behaviour and conduct. So I'm advised that in relation to Ms Folbigg's first petition, which I was not involved when that was lodged, there was no communication virtually at all over that 3 years with those acting for Ms Folbigg about what was going on. It was just, oh yeah, soon, in the near future. And during the second inquiry of which I acted, petition rather, there was very little meaningful correspondence sent on behalf of the Attorney General in response to our letters. So we were given the same bureaucratic non-answers of, soon, in the near future. And you can really appreciate our frustration given that the same Attorney General and his predecessor collectively took 3 years to act on a matter. It's just not good enough when someone is sitting in jail, there's persuasive evidence to just delay in the absence of no reasons. So the last point that I want to talk about, which I think is in some ways the most significant, is the intersection with review and politics. The Attorney General in New South Wales, and I'm assuming it's similar in other jurisdictions, is both an elected member of Parliament and appointed as a first law officer. But that can be really problematic in the context of post-conviction review. As we all know, the saying is justice seen to be done and done. But here the perception, even if there is no actual conflict, the perception of conflict is enough to be concerned about the decision maker. Because, for example, the Attorney General's role is broadly responsible for the administration of justice, but the Attorney General is also the responsible minister for the Director of Public Prosecutions. Guess what? The very agency that pursues the indictment against a person at trial. So even if the Attorney General has no day-to-day interaction or any influence over the DPP, it really doesn't bode well that that person has to decide if a potentially serious miscarriage of justice gets a review. And they also oversee the very organisation that in many cases their conduct contributed or caused or exacerbated the miscarriage of justice in question. So as we'll be talking about in the panel, and I know that everyone's interested to talk about the CCRC, in the United Kingdom 26 years ago, so as part of the establishment of the Criminal Case Review Commission, there was a large review into criminal justice in 1991. And it revealed when convicted people were asking the Home Secretary to review their conviction, so Home Secretary's similar role to the Attorney General in New South Wales, they were not referring cases for political as opposed to legal reasons. What this finding revealed is that the influence politics can have on a decision maker who is straddling both political and legal worlds. This is particularly problematic in high-profile cases and cases in which the legal system or government agencies have made errors. And there's, in my experience, a real reticence to acknowledge failure. Despite the system, in my view, not being designed for people to succeed, we did it. It took us far too long and caused significant trauma to Miss Folbigg and those supporting her. But on the 14th of December last year, we did it. Dr. Robert Kavanagh and I are now engaged in seeking compensation for Miss Folbigg from the state, and we very much hope that the state will promptly and compassionately deal with this matter in a way different from how they've conducted themselves in the last 24 years. So, in summary, it is my firm view that post-conviction review in New South Wales lacks significant accessibility, independence, transparency and accountability. My working with Kathleen Folbigg for the last 7 years has given me a unique insight into how the system works on the ground, face-to-face, every day. Our criminal legal system is said to be generally well-functioning. We probably get it mostly right. But when we don't, it is important that we have a system capable of timely identification and rectification of these errors. The principle of finality is not under threat just because our system has further safeguards for the small number of meritorious cases which are caused by human error. A robust post-conviction review system is instead representative of a progressive legal system, taking responsibility for all cases, the ones in which justice has been done. Oh, that's my thing to stop talking. And the ones in which our human institutions fail. In my view, it is not the failure or mistake which should define us. It is the action taken following identification of the mistake on which we should be judged. Nearly all significant changes to post-conviction review internationally have been sparked by failure, disaster, or scandal. In the United Kingdom, it was a series of high-profile miscarriages of justice which prompted action. Imprisonment of a woman for 20 years after loss of her 4 babies is a catastrophic failure beyond, I'm guessing, any one of our imagination in this room today. It is my hope, and I know it's Kathleen's hope, that her case might be the catalyst Australia needs and has to review their system of post-conviction review and look to making our system the best it can be. Thank you.